The Consumer Guarantees Act by Kelvin, Lilly, and Quinn.
The CGA involves dealings between consumers and suppliers/manufacturers of goods and services. However, this excludes businesses as consumers and business-to-business dealings if both parties agree to fair terms. The CGA also excludes the goods and services that are supplied, which are then resupplied in trade, used in production/manufacturing, or used to fix other goods or fixtures on the land of the business.
Section 2 of the Consumer Guarantees Act describes a consumer as a consumer who is anyone who buys products or services that are ordinarily used for personal or household use, which means computers would be considered a product for ordinary personal or household use. This, however, would not be the case 20 years ago, when computers were expensive and not many people used them for personal use. Therefore, the definition is dynamic and changes over time. Organizations or businesses who buy consumer products or services are also covered by the Consumer Guarantees Act, unless contracted out.
Guarantees given to the consumer by the CGA are in terms of the supply of goods and services. For the supply of goods, Section 6 deems that it must be of acceptable quality, meaning that it is acceptable in appearance, free from minor defects, safe, durable, and fit for the purposes for which goods of that type are used. Section 8 determines that goods supplied must be fit for a particular purpose if that purpose is known to the supplier, unless it is not reasonable to rely on the expertise of the seller. The CGA also makes it clear that the good must comply with description on package, be the same with the sample or demonstration model, the supplier must have repairs/spare parts available, and that the manufacturer honours express guarantees. The CGA also makes it necessary for a service to be done with reasonable care and skill, be fit for a particular purpose, be completed in a reasonable time, and the price to be fairly agreed on.
As a consumer, you have the right to ask for a remedy under Section 12 of the Consumer Guarantees Act for any consumer product or service that you are unsatisfied with. Your first step will be to speak to the supplier as soon as you notice a problem with the good or service. For a minor problem under the Consumer Guarantees Act, you will get repairs done, and if it cannot be repaired, replaced, or refunded the purchase price. If there is a major issue with the good, you can ask for a refund up front. An example of this would be if the good or service was unsafe or substantially unfit for its common purpose. In circumstances where it is foreseeable, you may also claim for damages caused as a result of a fault of the product or service. This is called consequential loss. And in a situation where you find you're not getting anywhere with the supplier, you can bring your case to the dispute tribunal or district court.
In most cases, sellers cannot exempt themselves from the obligations under the CGA. For example, you cannot put a sign up in your store saying no refunds. This would be a breach of the Fair Trading Act, as you are misleading customers about their rights under the CGA, which can lead to fines up to $200,000. In limited circumstances, you can contract out of the CGA. This would only be allowed for business-to-business transactions and would have to be in writing that the CGA does not apply and that both parties must be in trade and the terms be fair and reasonable.
As a business, you will need to ensure that you meet the criteria for the products and services you sell to consumers. This means, as a business or manufacturer, you will need to invest in meeting the guarantees outlined in the Consumer Guarantees Act and offer remedies for customers if these standards are not met. Practically, you'll need repair facilities, refunds or replacements available for a reasonable time, as this is enforced strictly under Section 12 and 19 of the Consumer Guarantees Act. This might mean making arrangements with manufacturers or repairers. And if you do not have spare parts available, you will need to inform your customers. As courts favor the consumer and enforce strict liability on businesses, therefore, it is necessary to follow these standards carefully to avoid litigation or disputes.